Kanye West's former assistant now has a second amended complaint against the legendary rap artist. Let's talk about it. All right, as you can see, this original lawsuit was filed in 2024, looked like June 3rd, 2024, and it alleged all these things, as you can see here. But in her second amended complaint here, it says that a new one was filed by the former assistant a few days ago. I don't have the exact date, but it says here, now in the second amended complaint, she has alleged that Kanye West, orally did things to her without her consent and coerced her into complying with his sexual demands by making false promises about the advancement of her career. Now, like I always tell you, lawsuits are just the allegations of the plaintiff. Nothing has been proven yet. There has been no settlement, nor has there been a jury verdict to discuss liability. These are just the plaintiff's allegations. So don't be so quick just because someone is sued. You're in the media say, oh, well, this person did this. Nope, that's not the way it goes. In fact, Kanye West, his representatives state that this complaint, even the amended complaint, claiming that accusations are, quote, absurd and outlandish. Well, that may be true. We don't know. It says here the courts are no place to indulge in delusions and mental disturbances, says one of Yeezy spokesperson, says, we stand ready to annihilate Miss Pisciotta's tall tales before a jury and exoneration so inevitable that even she, lost in her fog of fantasy, must surely see it coming. Now, it's important to know that Miss Pisciotta, I think that's how you pronounce her name, is the plaintiff and is alleging that she was Kanye West's assistant. Now, let's go over here to the lawsuit and see what exactly she's alleging, because she, as you can see here, man, this lawsuit is just riddled with all kind of allegations regarding her time spent with Kanye West. And it says here that in or about July 2021, defendants Kanye West, aka Ye, an individual, and those 41 through 50 inclusive, contacted the plaintiff and requested that she serve as a defendant's executive assistant and personal assistant in connection with the business affairs of all the defendants herein and the personal affairs of Kanye West, aka Ye. So, okay, so now you see that there's an employment situation going on to where she's alleging that Kanye West, as well as all of his business entities, hired her to be an executive personal assistant. Important to note, though, I don't see any, she didn't say anything about a writing offer in terms of an offer of employment. She just says, hey, he requested that she serve as his personal assistant. So let's keep going here. It says here, at the time, the defendant stated to the plaintiff that he was impressed with her prior tenures as a defendant's employee and that they agreed on a salary for the plaintiff of $1 million per year. Defendant Kanye West, aka required the plaintiff that the plaintiff be available to him 24/7 in reliance on the defendant's representation. Plaintiff accepted the annual salary and she agreed to work for the defendants as the executive and personal assistant and began doing so as a full-time employee. Now, again, like I just said, there was no offer of employment. There was nothing written. As you can see here, he requested and he asked, but nothing about a written. And typically, when you have in contract law, certain contracts need to be in writing. However, not all have to be in writing, and I don't want to, get into all that, but there are certain contracts that must be in writing. But I want you to know the lawyer's language here for the plaintiff. The lawyer said in reliance upon. That's going to become important later as I keep on discussing this, because since there was no writing, they're trying to say, hey, man, as you see earlier up here, they're suing for breach of contract. And they say, well, we don't really have a contract here, but we just have some sort of reliance on some sort of promise or agreement that the defendant Kanye West has made. So let's keep going. It says here that at all relevant times, Kanye West, aka Ye, was aware that the plaintiff maintained a strong social media presence comprised of her Instagram and OnlyFans account, the latter of which she ran entirely by an independent management company. He did not have any issue or objection to it. To the contrary, Kanye West, aka Ye, often boasted to friends and colleagues that the plaintiff was an OnlyFans superstar. Plaintiff's social media presence included, but not limited to, the Instagram and OnlyFans account and content of, among other things, professional bikini and lingerie photographs as a result of professional and tasteful photo shoots. Plaintiff's social media presence generated approximately $1 million a year annually. $1 million. Much later, in or around August of 2022, defendant Ye stated that he wanted the plaintiff to be more, quote, godlike, and asked plaintiff to delete her OnlyFans account. Defendant Ye agreed to pay plaintiff $1 million if she did so. In further reliance upon defendant's representation, plaintiff deleted her OnlyFans internet account, thereby giving up the annual sums generated from such account. Kanye West, aka Ye, never paid the plaintiff as promised. This is going to be the crux of this lawsuit here regarding the breach of contract claim. And let me explain that for a second. You know, because when you go through the rest of this lawsuit, and I don't even want to talk about the rest of the stuff because there's a lot of text messages and photos regarding how he sexually harassed her and sexual hostile work environment. And there's pictures and photos, but let me just deal with this whole contract issue regarding her deleting her OnlyFans account, and he agreed to pay her $1 million. Here's where the breach of contract comes in. See, because like I mentioned earlier, contract law dictates that you have to have certain elements to have a valid contract, okay? You're gonna need an offer, acceptance, and consideration. Those are the three basic elements you're gonna need to have a traditional valid contract. When you don't have those contracts, California has a law, kind of a California case law that they created, a judge-made law, if you will, called Promissory Estoppel. Promissory Estoppel shows that, okay, you know what? We didn't have the traditional elements of a contract. We don't have the offer, acceptance, and consideration, but we do have Promissory Estoppel, which is a remedy that the courts in California and in some other states too have definitely relied upon to grant the plaintiff's claim about a breach of contract. Say, hey, you know what? We know you don't have the traditional elements of a contract, but the plaintiff relied to their detriment. It was foreseeable, and as a result, it'll be unjust to allow the defendant to keep their money, and therefore they need to go ahead and pay the plaintiff because of promissory estoppel. I want to show you the elements here now. The elements of promissory estoppel are pretty clear, and it's been all over California case law. It says that the elements of promissory estoppel is when you have a clear and unambiguous promise in its terms, reliance by the party to whom the promise is made. The reliance must both be reasonable and foreseeable, and the party of certain estoppel must be injured by the reliance. And that's why you saw the language in that lawsuit. The lawyer kept stating that she relied on this. There was a clear promise, hey, delete your OnlyFans and I'll pay you $1 million. And she deleted it. And then since she relied on his promise, that's what you see in the lawsuit, say she relied on it, and she relied to her detriment. It was foreseeable that if she did do what he promised her to do, the terms were clear. It was an unambiguous promise that, hey, if you do this, I will do that. Then she did it, and as a result, to her detriment, she is injured to no longer generating the $1 million at her OnlyFans account that she alleges in this complaint, which is why she's suing here for breach of contract. Now, if you go further in this case, she talks about other things here, but if you go further, she also discusses that on or about September 13, 2022, defendants Kanye West and all of his companies offered the plaintiff a well-deserved promotion to the role of chief of staff for the defendants Yeezy LLC, Yeezy Apparel, Yeezy Footwear, Yeezy Construction, Kanye West, and Ye, all of these entities. And she says Kanye West, aka Ye, told the plaintiff that she was getting an additional $3 million as a result of her well-deserved promotion to chief of staff. So remember, the first job she was hired as the executive assistant and personal assistant to Kanye, or aka Ye, and all of his entities. Now they're promoting her to the same entities and the same individual to chief of staff, and he says, and for this promotion, $3 million. Now, if you look here, it says thus plaintiff's salary for working for the defendants in each of them, the sum was now $4 million. Plaintiff, in justifiable reliance on the representation of the defendants of each of the accepted new position, began performing the services of each of them and her now chief of staff role. Now, as you can see, they're setting it up to where, hey, listen, man, we may not have the traditional terms to make an actual contract, but the plaintiff justifiably relied to the representation of her employer, Ye, Kanye, and also all of his business entities. It could be said, he made this representation and she justifiably relied. There's another clear and unambiguous promise in the terms. Hey, I'm promoting you, and as a result of a promotion, I'm going to give you an additional amount of $3 million, clear and unambiguous. And then she relied to her detriment, and as a result, she was offered $3 million. Now, as you see here, it says on September 16, 2022, plaintiff contacted the defendants, and each of them inquired about the raise and would they be paid in a lump sum or in installments. Defendant did not respond on that date. However, on the next date, on October 11, 2022, defendants, Ye, and all of his business entities advised the plaintiff that she would be paid in a full lump sum that day regarding the $3 million. However, it says here the defendants did not pay the plaintiff as promised. Here we go again with the promise. They're sticking with the elements of promissory estoppel. And it says, despite this great satisfaction with the plaintiff's job performance, defendant and each of them continued to fail to pay the plaintiffs as they had previously promised. Here we go again with this promise, man, because they're steady hammering point the home like, hey, listen, we don't have the terms of a contract, but he promised, and it was clear and unambiguous, and there was actual reliance, it was justifiable reliance, it was foreseeable that the plaintiff would rely on the defendant's promise, and as a result, she is damaged to this amount. And if you keep looking here, this is interesting here. It says, in fact, several occasions defendant Kanye, aka Ye, and his entities, and each of them, in an effort to continue to induce reliance on the plaintiff's part, created a group text with the defendant's accountant and plaintiff instructing that the plaintiff be paid $3 million, but then stopping the wire payment of money each time. Meanwhile, the plaintiff continued to rely on the defendant's representation that she would be paid her salary, stated salary, and continue to perform her job responsibility to the defendant. Plaintiff also advanced many costs necessary for the performance of her services to the defendant, and each of them including and all these charges that she racked up. And it says right here, on or about October 21st, 2022, defendant and each of them terminated the plaintiff's employment, offering the plaintiff a severance of $3 million offer acceptance, and she said she accepted it. Defendant then reneged on the commitment to pay the severance. Now, that's a little bit different because this is now an actual offer. If you offer a severance and then she accepted in exchange for consideration, where you have exchange for promises and performances, now you have a contract for the severance pay, not the other pay that she was talking about. So this is interesting. And it says thereafter, the defendant, on or about October 28, and ask each of them if they can perform additional services. Again, promises and agreeing to pay the plaintiff severance despite having wrongfully accused the plaintiff of extortion. In reliance upon said representation, plaintiff performed, even after she was fired, she still performed such services for the defendant and each of them. She also advised the defendants in response to their false accusations that the plaintiff engaged in extortion that she had done what was requested and that she be paid as promised and agreed by the defendants, and to induce further reliance on the plaintiff's part and to secure continued services, defendant on or about October 31st, 2022, again created a group text with the defendant's accountant and the plaintiff instructing that the plaintiff be paid. Plaintiff, however, was never paid. Now, again, like I said, this lawsuit involves all kind of salacious sexual material regarding trafficking, alleged trafficking, alleged forcing, and all kind of sexual crimes, being alleged here. But this is where the cause of action, breach of oral contract, as you see here, they're alleging breach of contract, and they're basing the breach of contract on the promissory estoppel. And if you look at the prayer for relief, which always happens in lawsuits, you go down to the prayer of relief, and the prayer of relief is basically what you're asking the court for. You're asking the court, say, hey, this is what it is. I've showed you everything. These are my allegations. Now, what do we want? It says, wherefore, plaintiff prays for the court, compensatory damages according to the proof and pre-judgment and post-judgment, punitive damages, attorney's fees, labor code, injunctive relief, and so on and so forth, and any other relief that the court may deem proper. Now, I can tell you that promissory estoppel works a lot in California, and if they can prove that, then they may have a solid case. I don't know, but now that you hear all this regarding her, Kanye asking her to say, hey, delete your OnlyFans and I'll pay you $1 million, and also for your promotion is under $3 million. And, he said he never did it. He kept stopping it. You tell me, what do you think? Do you think that there's a solid case here, especially with this new amended complaint where she added new allegations of sexual deviancy and all that stuff going on, but she is suing clearly for a lot of money? I want to hear your thoughts on this case and promissory estoppel. Do you think she has a good case? Do you think that Kanye's lawyer said, hey, they were to deface her? As you said, that they have denied everything. They were to deface her, and they said, and all these claims are absurd and outlandish. I want to hear from you. And it's important to note that 98% of all lawsuits settle, so we don't know what's going to happen, especially with this new amended complaint. So you tell me your thoughts. You think there's actually promissory estoppel here? Do you think there's actually a contract for her to rely upon? She continued to work after she was fired and perform such services on his promotions. You tell me. I would love to hear your thoughts. Like, comment, share, subscribe. It's your brother, Attorney Jeff.